All right, let me try to put this into perspective about finances that the legal system interprets. How does the legal system interpret finances? Let me start out with the prosecutor. The prosecutor thinks that GoFundMe is income when it's donations, but he associates that as income. And that was Prosecutor Benjamin. Judge Owsley, the first judge I had for trial number 1, he says that he trusts the public defender's office to determine my finances. And if the public defender's office says that I have enough money, he's not going to question that. He doesn't even bother looking at the paperwork. He just makes sure that it's, or he says he looks at the paperwork, but he delegates that to the public defender's office. So the appeals court wanted to see that as part of their determination. The appeals court is willing to look at the financial issues involved, but if they're not present, then they'll make a decision saying that there's not enough evidence to support Judge Owsley's claim that I had enough money, or that I didn't have enough money, or that I had enough money, whatever, with a public defender. And that got remanded. But that, if you think about it, that appeals court could have just simply denied my writ, saying that there wasn't enough paperwork involved, because that's what they did with my second writ. And now I apply again with the public defender's office, and they look at my savings account as the primary means of being able to afford things, and they say that with $20,000 in savings, that's not going to cause me hardship. Okay, with the way I'm living, with the things I have, I said I got a super old car. I mean, that money goes fast for accidents, but they're saying it won't cause me a hardship. Okay, so if a hardship happened, medical, some kind of financial disaster, car breaks down, whatever, and they declared, the public defender has made a declaration that he thinks I have enough money. He had a notary sign it. Okay, let me just pull it up here. He had a notary sign. He made his declaration that he felt I had enough money. Okay, and it's back in November. Oh, but I put it, that's right. I'm changing. Okay, public defender notary. In the case entitled State of Louisiana versus Travis Hines 170969 in Natchitoches City Court, pursuant to preliminary determination by the court, the defendant made an application to the IDF, which is defender form, for the appointment of counsel. In support of his application, defendant completed a detailed statement concerning his income, assets, personal, and financial status, which was stated by the defendant officially to be true and correct. After review of the information provided, the IDF determined that the defendant is not indigent within the meaning of Louisiana Revised Statute 15-175, as he is able, without substantial financial hardship to himself, to obtain competent qualified legal representation on his own, considering the seriousness of the charges, local council rates, and particularly the substantial funds in his bank accounts. So he's Ted Brunson is the guy in charge. He's saying that any accidents that happen to me, okay, medically or whatever, he's putting himself on the line, saying that he doesn't think that I'm going to suffer financially if something happened. He's hedging his bets on nothing horrible financially to happen to me. Not like I could lose my lawsuits against the library and have Goldweems come after me for $20,000, like they were successful on a civil rights lawsuit with a former employee of Natchitoches. A former employee sued the city of Natchitoches back in 2020 or maybe 2019. It was settled in 2020, and lost his civil rights lawsuit, and the city went after him for $20,000 to pay for the legal fees for this bloated law firm, charging $20,000 to defend the city. And this Goldweem says that they are civil rights lawyers, but they're you see that and you think, wow, there must be some good guys there, but that ain't the case. They're on the other side of the civil rights. Okay, so some guy felt, some former employee felt he was wrongfully terminated, sued, and now he's not only owes his own lawyer fees, but he also owes Goldweems $20,000. And that's what I'm facing too. I'm facing having to, maybe losing my lawsuit against the library over my permanent ban, and then having to turn around after a loss and paying Goldweems $20,000 for their bloated law firm, because they got to have backups to the backups getting paid to sign off on responding to my lawsuit, where it's just me against them. Okay, and they're gonna do the same, likely do the same thing. I mean, it just happened with this civil rights lawsuit, and I'm pretty much filing a civil rights lawsuit as well. We're in the discovery phase, and it's a fight. All right, they want to know my financial. They want to know if I'm a sexual offender. They want to know if I've sued a lot of other places before. How many times have I got arrested, banned from libraries? They're going all in on this with their defense to keep me out of the Natchitoches library. And then they're going to turn around and sue me for $20,000 like that civil rights lawyer. And then guess what, Judge Barber? I'll be in debt. I'll be in debt to Louisiana. And then, yeah, maybe I will qualify. Won't that be the way to do it? I'm trying to take it in a more honorable fashion here, though, and go through this appeals court. So, like I mentioned with the public defender, he says he's putting it on himself. Ted Brunson's putting it on himself that he's declaring with a notary present. Whoever the notary, I found interesting too. Let me just say that they're Mark Begnaud. It says my commission expires at death. Okay, I thought that was interesting. My commission expires at death. So there, from that, during that hearing on December 11th, Judge Barber chose the side of the public defender with my financials. He took into consideration the declaration that the public defender doesn't believe this is going to be a hardship for me. Oh, they're only $1,500. Oh, I've interviewed other prosecutors who say they don't even have $20,000 in their savings and checking accounts, you know, and I didn't delve deeper into that, but I'm sure their money's elsewhere. And so Judge Barber takes all this into account, and then adds up my savings as part of an annual income. So you could accumulate into your savings accounts at a slow rate, at a fast rate, whatever you put in there, and it don't matter. Every year in Judge Barber's financial calculations, every year your savings account is part of the annual income. Okay, it's not safe from his grasp. And I'm appealing this to the Third Circuit Court of Appeals. I'm working on it. I'm writing it, and I want to know what they think. All right, they'll probably deny me for not having enough paperwork because Judge Barber's giving me a hard time about giving me paperwork. So that's another part of my argument. Judge Barber's dragging his feet on paperwork, particularly the transcripts for the last hearing, where we actually have what all he said on the record, calculating my savings as part of my annual earnings. That's not something that is reflected in the court minutes. It's talked about in the transcripts. But Shanita, the court clerk, says it's going to take 30 to 60 days, and I don't have 30 to 60 days. I mean, that's typical Louisiana business for you. Dragging their feet, dragging their knees, dragging their hips, dragging their elbows through the swamps. That's how they work it. Whereas if I go to Kentucky and say, hey, can I have a transcript? And they'll just say, here's a CD, give us $25. Whereas with Shanita, she's like, give me $200 down payment, and it'll be within 30 to 60 days. Looking at past my trial date, and I'm trying to writ for December 11th. So money and time are two categories, are two topics that the court system is not qualified to make determinations on. You need experts to step in and explain the money and time to the court system, because they just don't seem to have a concept of it. And you know what I find interesting is there's this AVI Geeks YouTube channel. AVI is, I don't know, audio visual. It's the old timers, old videos, like classroom instruction videos. I've watched quite a few of them from the 30s, 40s, 50s, 60s, 70s, just at times periodically. And throughout a lot of these, there's been a lot of talk about the concept of time. And I find that interesting. People are really fascinated about time, and they've been fascinated about it for years, just how it works and all of that. And it's a topic that is discussed and presented to classrooms and with many different videos in the past, from old videos. And it's something that I think maybe Louisiana judges have not seen these videos. And these are old judges. Judge Barber, what is he in his 60s? I mean, these are old videos. I mean, you know, it's film, so it's hard to transport film to all the classrooms. So, you know, I think I got skipped over, I'll say, for that type of video. But I'm watching it now. Everybody now has the opportunity to go on YouTube and watch this, to learn about the concept of time and money. All your legal training does not prepare you for discussing money, as evidenced by the conclusions, the orders, the determinations, the rulings made by the city courts, and the ideas that they come up with. But I'm appealing, and my call to action right now is I'm appealing this to the Third Circuit Court of Appeals. I'm working on that writ, and I hope to get that out soon.